Good morning. Eugenia Matthews, Talking Law with Eugenia, and I am in the studio on a Saturday after having a nice evening out last night, perfectly sober by the way, with my guests Miles Harper. Good morning, Miles.
Yes, good morning, Eugenia.
Now, Miles is from Harper Davison, 82240277, and my other guest is Henry James of Henry James Legal, 0414414520. I remembered. Good morning.
Good morning, Eugenia. Lovely to be back on again.
Okay, now we're going to continue the discussion because you've asked us to talk about loans between family members and friends, and we did that a couple of weeks ago, and now you want us to take it to the next level, which is what happens if you're lending money to family or friends when you separate. So how does it affect property settlement? And also, how does a loan between family members or friends affect deceased estates? We're going first, as we always do, with a song from John Cougar. I always say John Cougar Mellencamp. Check it out. And a reminder, the program is brought to you by Adelaide Hills Toyota. Enjoy the song. And we're back talking law with Eugenia. The program brought to you by Adelaide Hills Toyota. I'm with my guests, Miles Harper and Henry James. And we're going to continue our discussion on lending money, so between family and friends, but particularly family when we're talking about property law. If it's deceased estates, it could be family or friends, whatever. But we're going to start with a question that was sent in to me, and Miles will start the discussion. In fact, the boys are going to lead this discussion. The question is, a parent lent money to her child, a son, to buy a house. He and his wife are now separated. The wife says it was a gift and they did not have a formal arrangement. What happens? And it's over to you, Miles.
Thanks, Eugenia. It's not an uncommon...
Speak into the microphone.
It's not... sorry about that. It's not an uncommon problem where people have lent money to their children and then subsequently their child, who's had the benefit of the money, ends up separating from their partner. It happens all the time.
Unfortunately?
Yeah, unfortunately. Brokenness and dysfunction is, what humans are like, and if they didn't have that, then they wouldn't have to have any lawyers. So I think we'll go ahead with that dysfunction still. So I've still got a job. The rationale, however, on a more truthful and less flippant basis, because of course these things are serious for those people involved. If it's a question of evidence, if there's been a loan given to a child to buy a house, and that partner and the child buy a house with it, and then they separate, it's very common. In fact, it's normal for the person who didn't get the gift, the wife, I think, in the case you're talking about, to say, that money was a gift to us and it forms part of the asset pool to be divided between us. And the reason she says that is it increases the size of the asset pool and the amount of money that she's otherwise likely to get. So it's not a surprise. The question is does it form part of the asset pool or not? That's a question of evidence. First of all, is there an agreement? No, there isn't an agreement. So there's nothing in writing. So it then becomes a question of the child saying, yes, it's a loan, and their parent saying, yes, it's a loan, against the voice of the wife or the female partner in this case. And she'll be saying, well, no, he told me this, and he'll be saying, no, I said this, and his dad or mum will be providing an affidavit to the court saying, no, it's not a loan. And then it's going to be a question of what the judge decides it is.
That's correct. But as we know, it always causes trouble in a marriage, and then people start getting a bit silly and arguing about the children. So if you've got children, it's really important if you borrow money from mum or dad that you document it, because you don't want to have a bun fight. I assure you, if you're going to have a dispute about this, and you should always assume that you are, that you put it in writing, because I can tell you who's going to make the money, and it's not going to be you two, it will be your solicitors.
And that's really where the drama starts, and it leads on from where we were taking the subject previously, where we talked about lending money to family members generally, is that one of the biggest pitfalls of that is that you go into it without that commercial mentality that you should be going into it with. So you almost go into it almost as though you're gifting the money to your relative. Often you're not going in thinking that, okay, this is a commercial loan where there's repayment terms, there's a deadline for paying me back. I want to be paid back this amount each week or whatever. There's no documenting of the agreement. And the problem with that is that, as you say, when it all goes pear-shaped and the people that once loved each other now hate each other, it's very easy for them to turn around and really recategorise the relationship and say that, oh no, that was a gift, rather than what everyone thought they'd previously agreed to, which was that it was a loan. Now, if the two people had been commercial from the outset and had even thought to even write the most simple agreement on a one-page piece of paper, something that documented the arrangement, it'd be better than just the he said, she said, she'll be right down the track kind of mentality that people invariably adopt when they lend money to each other.
That's true. One of the things which we haven't mentioned yet is there is a presumption that when a parent advances, i.e. provides money to a child, that it is a gift. And that's a legal principle, the presumption of advancement. And the son, in the case with the person who'd written in, sorry, they wouldn't have written in this day and age, would they?
They texted me.
They sent a text. So in regard to that person, they've got to get over this presumption that it actually was a gift. And it might be that if they look through emails that their parents sent them saying, look, I'll give you the $250 or whatever it is, however much it was, but I'm going to need it back, so it's a loan. There may be some written evidence around it somewhere to sort of justify the fact that it was a loan. There may be texts. There may be other things saying, look, I'm getting the money together, but you really are going to have to pay this back at some point because I don't have enough to retire on, or whatever it might be. So they might have the ability to prove that it actually was a loan. And then getting to some evidence, as Henry was saying, is better than nothing.
But keep in mind, though, that piecing it together after the fact by trolling through text messages and email chains and whatnot, that's all work that your poor old solicitor's going to have to do, and they're going to send you a bill for it. So you're always better off having that formal written agreement to begin with, because piecing it back together again at the end is going to be a very drawn-out process for your solicitor, and it's going to cost you more in the long run.
That's true. Dealing with our texter, the best thing they can do is try to find the evidence. They need to go and get some very specific legal advice as soon as they can, and then go through that evidentiary, try to find do some searches of the evidence as to when the money was transferred, what all the discussions were at the time it was done. So that's really important, because as Henry was saying, usually these things are done in love and care and at the time, and love's all very well. I think somebody said it doesn't pay the bills.
No, it certainly doesn't.
And I understand love may make the world go round, but hate makes it go round faster.
True. Okay, so another question, still on the family law topic, is from a lady. Her partner lent her money before they married. They've now separated. She was paying back, stopped when they married, and now he wants her to pay the outstanding loan. Does she have to pay him?
That's a good question. I might have the same question one day if I ever have to pay rent to my wife when I was living with her.
I've got
to
a
start
note.
with. I didn't have to. At some point, she just told me to stop paying rent. So I might end up having the same issue come back to haunt me too.
Same here, because my husband lent me money for my practice. Love you, Rodney, but I have no intention of paying you back. I can hear him. Oh, texting. I
Yes.
didn't mean it.
I can see some smoke rising over a certain part of Mount Barker.
I think I'm sharing the room with two people that can't afford to ever get divorced.
I think you're quite right. So going back to that, the poor texter who has paying her husband, presumably her husband, money in terms of repaying a debt to him, and then didn't have to repay because they got married. Then and now they're separated, and of course he wants the money. I would think, in general terms, because our advice here is only general and not specific, because we don't know all your full circumstances. The first point is to go and get some specific legal advice after, as soon as you can. But the general thought would be, well, look, what he lent you, and all your other assets and all your other debts. I would tend to, if someone like this had come to see me, I'd lump all this in together and go, you know what? Everything can just sit. Do nothing. Let's look at all the assets and liabilities, and we'll deal with his debt, but you're not to start repaying it now. That would be the general feel, not specific advice.
Miles, do you find that in these situations it can often open Pandora's box where one person says, yeah, but I lent you 10 grand back 5 years ago, and then the other other partner can really come back and say, well, what about the money I lent you? And then it's this back and forward about partner A lent partner B money and partner B lent partner A money throughout the course of the relationship, and it almost becomes like a petty point scoring.
It is, yeah. I fixed your car. Yes, but, I was extra loving to you because you did that sort of thing. And then suddenly there is a lot of point scoring going on. It's a matter of finding out what you think the asset pool is, including all the debts.
You know what? When clients come to me and they do that, I fixed your car, boy, and I lent you this to buy your watch or get your new dress or whatever, I always say to them, look, you need to be sensible here. That's marriage. It's give and take in a marriage. We're talking about loans that are generally outside. So, for example, in my situation, I got lent money to start my practice. Now, I personally consider that to be a loan. And obviously, I've been paying back, and I intend to pay it back. There you are, Rodney. I've given you something on radio to use.
Yeah, tape that.
Take that. But I think, really, in the ordinary course of events, marriage is give and take, and I don't think they will make themselves look good in court at all if they start going, oh, well, I fixed your car and I replaced the pole on the pergola. That's just normal marriage.
That's quite right, Eugenia. However, if it's a large sum, for example, there's an asset pool of $1 million.
Yep.
I lent you $80,000.
Mindset is that you're lending money often without any form of security over what you've lent. So in lay terms, meaning if you've lent someone 100 grand, you should be able to say to them, if you're not able to pay me back, then I want to take your car that's worth a reasonable amount of money, or that very expensive piece of jewelry that you've got, or just something in exchange that that you can take if they're not good for the money when squeezed.
Yeah, so that would, if in relation to personal chattels, what I mean by chattels, I mean things like cars, equipment, those sort of things. You can register, you can lend people the money, but you register effectively a charge on the PPSR system, and it's too early, unfortunately, for me to remember.
Personal Property Securities Register.
Full marks.
I'm just
Mr.
showing
James. I'm extremely impressed. Very impressed.
Yeah, he taught me that last week, because this part isn't my area.
So you would make sure that the vehicle or whatever it was that you'd helped them purchase was on. You were on that register, so they couldn't then sell that car and pass title to somebody else. If it's real estate, then there's a number of different ways of doing it. One of which is a mortgage. You could get a mortgage, you lend the money,
and
you
register
secure it against land.
on the title.
Yeah, and
Yep.
it can be a first mortgage, it can be a second mortgage, or it can be a caveat. And a caveat just means that if you've put a caveat on someone's land because you've somehow or other contributed towards the purchase, conservation, and maintenance of that property, and it doesn't have to be very much, by the way, even painting the walls will give you a bit of a, an ability to put a caveat on it because you've improved the property.
Exactly.
But that means at least they can't sell it without you knowing about it. And they can't raise any more money on it if there's difficulty, I should say, if there's a caveat on it. So I think when we're talking about loan agreements, though, you and family law, and I'll leave Henry to discuss more in terms of the other ways you can do it. With that, you really want to have something quite formal. If it looks too informal, too rough, looks like you did it in the back of the envelope and it's got a coffee mark on the top right-hand corner.
Better than nothing, though.
Yeah, but
it's not.
Yeah, I know, but I have a lot of people have this idea
It needs
that
to be
that's
viewed
good
as
enough.
genuine.
Yes.
The court needs to not think that this is something that's been invented after the fact. It has to be.
Correct.
It has to look as though, okay, this is something the parties signed at the time and were fully cognizant of, and not something that Nana's gone and scribbled on the back of a serviette because she's worried after the fact.
Correct. Yes, that's absolutely right. So it needs to look like a commercial agreement. The other part of looking like a commercial agreement is, and this is the nasty part if you're the borrower, is that you'll actually have to pay some sort of interest on it. Because if you've got a nice formal loan agreement prepared by a lawyer, that's excellent. That makes it look like a very genuine loan. It makes it look like it's not going to be a gift. Obviously, this can only be done before people break up. But you do have to make some type of repayments, I think, to have any chance of it being seen to be credible.
Well, because the court's going to look at it and think, what was in it for the lender?
Exactly.
You know, if there's no financial gain or advantage for the lender, assuming the risk of lending out that money to the borrower, then why on earth were they doing it? If they're doing it purely out of love, then that does actually seem to sort of steer it more towards it being more of a gift type relationship than a lending type relationship.
Or
That's
at
right.
best, it could be it's an interest-free loan. Look, we're going to go to a song, but my bottom line is always this. When family members or friends come to you and they say, can I borrow some money? The banks are experts at managing financial risk. If a bank won't give someone a loan, think twice before you do. Now, we're going off to a song. It's one of my favourites, Ellen Foley, What's the Matter, Baby? And I think it's upbeat and really cool, so enjoy it. Okay, Talking Law with Eugenia. I'm Eugenia Matthews, your host, and I'm back. And my friends, Miles Harper from Harper Davison Lawyers, 82240277, and Henry James from Henry James Legal, 0414 414 520, assisting me with a discussion on borrowing money or lending money and what happens when there's family law property settlement or deceased estates. And again, the program, I'm very grateful to Adelaide Hills Toyota for sponsoring it. Okay, boys, let's continue the discussion. I'll start off by reminding everyone, if a bank won't lend your family member or friend money, think twice. Banks and financial institutions are experts at managing financial risk. If they're not lending, think twice.
I think also, Eugenia, that not only is that true, but just in general terms, if say a member of your family says, hey, I can't afford this property by myself, will you come in on the mortgage? You really got to think twice about that too, because this idea of, for example, mum's going to come to live with us, and this will probably something that Henry can perhaps comment on as well. It often ends up in estate issues where mum's going to come and live with us. She sold her house in Sterling for 1.5 million, but she's going to build a really lovely granny flat, small house in our back garden for 800,000, and it's on our land, and the land is in our name. That's all very well if Grandma and the people whose land she builds on get on well. If they don't, what happens? So that's one big issue. And the second issue is what happens to Grandma's inheritance, because she's put all that money into one child's property but not the other two. So those things, it's like a lending of money when Grandma decides to go off and do that. Now, if she builds a hideous house, and I know somebody who did that, but for reasons of confidentiality within my family, I'm not going to say it. But they build a house that doesn't add value to the land, then really you've got a $40,000 problem where it just needs to be put in a dumpster.
I mean, the first problem I can see is where you've got a family member that goes in on the mortgage with you is that despite how much they put into the mortgage, they still bear the full risk because any number of people on that same mortgage, if it all goes pear-shaped, the bank can go after each and every one of them in the same way.
For the same amount.
For the same amount of money. So it could be $1 million mortgage, and if Granny's put in only about 10 grand and her equity position is very, very minuscule in that mortgage, it doesn't actually matter. She can be as vigorously pursued as everybody else is on that mortgage.
Yeah, for the same amount of the mortgage, and that's really quite critical. So that's got risks both for Grandma and the people who live there, and of course in the inheritance case, the other two siblings who Grandma had say $3 million, but she spent most of it on the granny flat or on one child. It might just be that there isn't an equal share to go round, and you can't suddenly take off Grandma's house off or Grandma's flat off the back of one of the other children's properties. So in a sense, those things are all about, I was going to say they're not soft dollar loans. They're lending. They're becoming financially entangled with loans, but not in a way that you would identify as just necessarily as a single. Not in the way we've been talking about, where people have just been lending a certain amount. These are ones which are more complex and more difficult. And in family law matters, I mean, obviously, if Grandma builds a unit on the land, and then those two kids break up, she may not get her money back.
Absolutely, and when Granny a few years down the track does move on from this world, and her family are trying to divvy up her estate, say that she's built her $800,000 granny flat, and she's got 2 grandchildren. She's built it on the grandson's property. The granddaughter is going to obviously think to herself, well, do I get half of this granny flat? But it's actually on the grandson's property. So maybe there has to be a subdivision. It gets messy. It gets really messy.
It gets really messy, and you have to have arguments about, oh, well, grandson, in the case you're saying, he owns the land, part of that land in a constructive trust for the grandma's estate, and then there's issues about that, and then there's another argument about a thing called a resulting trust. There's all sorts of legal dramas about who owes what and who said what, and of course, as usual, there's very little proof because no one ever thought it was going to go and turn pear-shaped, and so on. So, so there are issues with that, and in relation to if the grandma's going to live in the property, then obviously she's going to be wanting a lifetime lease to preserve as best she can that if her grandchildren get divorced, the grandchild gets divorced and there's a property settlement, that she doesn't lose her position. So there are a few things that are really quite vital, because people go in with the best of intentions, and they don't see these things coming. But sometimes, if you decide to all live under the same roof,
Well,
eventually arguments happen.
Well, actually, there's a good point. In a separation, say that the grandson she's built the granny flat at the back of his property, say that he and his partner separate. Surely that would inform whether the grandson retains that property in lieu of cash, because otherwise, if it's agreed that property is to be sold off, what becomes of the granny flat? Does granny just get the boot despite what she's put into the place?
Well, apparently most people don't buy properties which include a granny. So apparently grandmas aren't sold with the land. They're not a fixture. So I'm told. So it'd probably, in many ways, it'd probably help a lot of people if the grandma was a fixture. But apparently that's not always the case. So it is a real issue because you don't know that just because grandma built a property worth $800,000 on the grandson's property, for example, doesn't mean that it's increased the value of the property necessarily by $800,000, because builders obviously have a profit margin of what they used to have of about 20%. I don't know what it is now.
Yeah.
So it may be that it hasn't increased the value. If the property is sold, grandma becomes a third party
to proceedings, I
to
would say.
proceed. That's right, in the family court.
It's a reality that blood, sweat and tears in and of themselves don't necessarily convert into title. Just because granny spent a fortune, she's put all the effort into building, it doesn't mean she actually owns anything.
Well, it also doesn't mean that whatever she put in as $800,000 is actually worth $800,000.
True.
So it means you end up having to get property valuers involved, and I don't mean real estate agent appraisals, but actual licensed property valuers. And then of course there's a lot more pressure on the grandson in that case if his wife's wants a property settlement, to try to retain the property. And what happens if grandmas generally, for example, in this instance, don't have necessarily a large income, and so to keep the property and remortgage it's going to be quite difficult.
Well, it is, because as we age and we end up on either the government pension or our own superannuation, which is a fixed income, we just don't have the ability to incur large expenses or be able to buy ourselves out of a property.
Well, people that borrow from their relatives are already financially constrained.
Yes.
And the second thing is, with an elderly person, banks aren't going to want to lend to them.
No, they won't. Well, they could do a reverse mortgage, but that's
Messy.
fraught. It's messy. It's fraught with difficulty.
And that assumes that older person has an equity position to begin with, and a lot of people, unfortunately, are going to be lifetime renters, and they're not going to have anything to put a reverse mortgage on.
I see the problem becoming more common, though, because the government is telling us, those of us with a quarter-acre block, build a granny flat at the back. So I see this becoming an issue in the near future.
Well, granny flats, the issue with that is that there are Centrelink issues if they're on the age pension.
Yes.
There are, apart from that, there's the inheritance issues I've said. There may be other tax issues. They may not go on the title of a property, because if they go on the title of the property, then there's a transfer of property going on, and that's going to incur a stamp duty fee. So there's a whole lot of things. I know we've sort of, what's the word for it?
Glossed.
No, segued. That's a modern word, isn't it?
Segued.
It's a modern word for elderly, Mr. Harper. Segued into that, but there are those loans that and other things that are not purely, just lending somebody $300,000 or $400,000. So, and how that functions. Certainly of family court matters, and I'll finish on family court matters and let Henry take over on estate planning issues. There are, and estates, there's also, if it does become litigious, which means it goes to court, and there is a third party involved, or is an issue about loan agreements, then often what happens is, if there isn't a lot of proof, then eventually there's a compromise made. So it may be that if somebody's very unfortunate and there's no evidence that the loan was a loan and it looks really like a gift, is they end up having to compromise just to get rid of the other person who's saying, well, this loan is a gift. And they end up losing as a result of not having it documented previously. Because on most family court matters, I'm pleased to say, end up settled and negotiated.
They do.
But when it's negotiated, as you know, Eugenia and Henry knows, it means compromised. Compromise means you don't get everything you want. So that will be the same with that sort of loan.
And really, in a sense, that's a hidden cost of borrowing money from your relatives, is that if it has an adverse effect on what you end up receiving in the property settlement when the divorce happens, then you have to ask yourself, was it even worth borrowing the money in the first place?
It's just nothing but fraught with danger. My position is, and I learnt this from my father, if you're going to lend someone money, it's something that you can afford to lose. It might be $100, $1,000, whatever it is. It's something that you should be prepared to lose. If you can't afford to lose it, don't lend the money. And again, I know it's a broken record. If the banks aren't lending the money, it's because they're not a good financial risk, and you shouldn't lend them the money either.
Well, it comes back to an old saying of mine, which is you can't fill a glass from an empty jug.
True.
If you haven't got the resources yourself, you shouldn't be lending it out to others.
No, that's quite true. The other aspect, of course, is if you are in the situation where you're lending money because these people can't get anything from the bank, that, you know, the necessary explanation, of course, is that if it does all go wrong, you may not get your money back at all anyway.
That's true.
Because there may not, just for a start, there may not be the equity to get it back out of. True. Especially once they've had a fight over it.
Yeah.
And some people do renovations that actually devalue the property. You're at the mercy of what's going to happen economically, and, you know, usually the price of houses goes up, but sometimes they don't. They go backwards.
Well, they can for periods of time. I mean, in the hills, for example, you know, around the Meadows area, at one stage it was, back in about 2007, before the GFC, it was $10,000 an acre was the rough rule of thumb for sort of buying any real acreage.
It's huge now.
And then it went down to about 7,000 about 6 years ago, and now it's closer to 14 from what I understand.
The other issue I can think of when lending money to family and there's a divorce is, what if you're not the only family member that's lent the couple money? And then when it comes to paying back each family member that's lent money, how does the order of priority work?
Well, I
like
guess
when you say that there's only if there's only a certain amount of money to pay people back, and one relative's lent 150 grand and another relative's lent 15 grand, which one gets paid back first?
Well, if none of them have security, then it's open slather, isn't it? It's just
Absolutely.
a big fight.
Okay, and the program's brought to you by Adelaide Hills Toyota. Received a text, like Ellen Foley. Thank you, so do I. We'll go to We Belong to the Night. I like that one anyway, so hey, I don't mind playing it for you, and then we'll come back and finish off. Talking Law with Eugenia, I'm your host, Eugenia Matthews. The program is brought to you by Adelaide Hills Toyota, and we're coming back for final comments and our discussion, as you know, because you've been writing in, and the boys were a bit upset with the person who asked for a song. We thought we were going to get a question for the show, but anyway, at least you're listening, so you're learning something, because that's why we give up our Saturday mornings. Okay, final comments, Henry.
Yes. I think when you lend money to family, it's one of those events that really should trigger in your mind the need to get your will revised. Because you can have this horrible situation where you've got 3 children and you've lent one of them 100 grand and you've not updated your will. If you happen to have the misfortune of carking it, then what happens then is that one of your kids has pocketed the 100 grand they haven't paid back yet, and then your will still says, I separate my asset. I bequeath my estate in equal shares to my 3 children. then arguably one kid's already got 100 grand out of you and then gets to go in for his or her third. That's really not fair to the other two children. So if you're going to lend a significant amount of money to a child, you really should be amending your will to say child A gets his equal share minus the 100,000 that I've lent him unless he's paid it back, or something along those lines. And a lawyer who's good at doing wills can help you out with that. But you need to be alive to the issue. I mean, we always say, there's certain events where you should think, gee, this is time for me to get my will, such as I've just had a baby, or I've just got married, or I've just become divorced.
Or separated.
Or separated. Lending a significant amount of money to a family member is probably another one of those situations where you want to be thinking, I need to get my will done.
Absolutely. You want to make sure that if you die, because you can't speak for yourself from the grave, your document is the only thing that will be speaking for you, and you want to make sure that you are relatively equal with any of your beneficiaries. And it also goes the same for family law when you're doing property settlement. If the money that has been borrowed is required to be paid back and you don't have a formal agreement that you've done properly through a lawyer or anything whatsoever to demonstrate that it is a commercial loan, then you're going to have some problems. You'll have to adduce evidence to the judicial officer who's going to have to decide, and that costs money. All you're doing is depleting your financial position, and you just don't want to do that. So take the time to do it properly. It might cost you a little bit of money, but it'll save you a lot of money if it turns to what I call SHIT. You just don't want to get there. The only people that profit from this are your solicitors. Now, if you can't afford a lawyer, you could go to the Legal Services Commission. They might be able to give you some advice for free. There are community legal centres. There's Miles Harper of Harper Davison, 82240277, or Henry James of Henry James Legal, 0414 414 520. And I might add, my very good friend Roma Williams of RN Williams Legal, 0424